Today we are looking at capacity and legality in the common law of contracts, and we're going to begin with capacity. Capacity is defined as the legal and mental ability to enter into a contractual relationship. So basically that you understand what you're agreeing to and what you're getting into. What we're going to focus on is how this relates to minors, and for our purposes a minor is going to be anyone under age 18. Now the general rule is that a minor can enter into any legal contract, but the contract is voidable at the option of the minor, meaning the minor can go in and cancel the contract. The minor can disaffirm the contract. Now, what's the rationale for that? Why are we going to let a minor enter into a contract only to let him cancel it later? Well, the idea behind that is that minors don't think the same way that adults do. If there's an adult involved in the contract, the adult is in the best position to avoid creating a contract with a minor. Get the parent or some adult in there to co-sign with them. So the rationale here is just to protect minors. If the minor chooses to disaffirm, they do have to disaffirm the entire contract, and generally they have to return the goods and pay for any damage or depreciation that has occurred or that they have caused. Now there are some contracts that can't be disaffirmed, one being where the minor has misrepresented his or her age, so there's some deceit involved there on the part of the minor. We're not going to let them out of that contract. The second exception there, if it's a contract for necessaries, food, shelter, things like that, but you've got to look at the minor's life situation to determine whether something is or is not a necessary. I mean, if they've moved out of their parents' house and are living on their own, maybe they have their own job, in a situation like that, it's more likely that the food, shelter, or transportation would be a necessary. Sometimes you'll run into a case where there is an emancipated minor. An emancipated minor is someone who has gone to court and the court has determined that we're going to treat this person like an adult. They're free from their parents' control. If the minor is emancipated, then for purposes of contract law, they're an adult, and so they would not be able to disaffirm. Now let's suppose that a minor goes out and makes a contract, and then the minor reaches the age of majority. They turn 18. Well, once the minor has turned 18, they can ratify the contract that they made as a minor, meaning they can accept and give legal force to that obligation, and they can do that within any reasonable time after reaching the age of 18, the age of majority. And that ratification can be express, so the minor could write something or sign something confirming that they are ratifying the contract, or the ratification could be implied, meaning based on their behavior. So for instance, that 17-year-old that goes out and buys a car could ratify that contract through implied means by just continuing to make the car payments after turning 18. Moving on from minors to persons under the influence. If you are under the influence, you're intoxicated or something like that, can you validly enter into a contract? Well, a contract made with someone who is under the influence might be voidable. The key question is, did the person have the capacity to understand what they were agreeing to? If they understood it, despite being intoxicated, then the contract would be enforceable. But if you could prove that they didn't understand, then the contract may be voidable. What about those with mental illnesses? If the person has been adjudicated incompetent, a court has concluded that the person lacks the ability to understand a contract and handle things for themselves, then any agreement with that person is going to be void. However, if a court has not made that determination, then the agreement would be voidable. But in that situation, we have to determine, did the person understand what was going on or not? Were they in a lucid interval? A situation where this may come up is people who have dementia or Alzheimer's. There are times when they understand what's going on and they understand what they're doing. They have those lucid intervals where they could potentially enter into a valid contract. All right, moving on from capacity to legality and enforceability. With legality and enforceability, there are some agreements that are not legal or not enforceable because they violate a statute. Certainly agreements for illegal activities, like selling drugs, would not be enforceable. Neither would an agreement that violates a licensing statute. An example of that would be if you signed an agreement with someone who you thought was an attorney to prepare your will, and later turned out that the person was not in fact a licensed attorney. They were violating a licensing statute, and so the contract you had with them would not be valid. Similarly, agreements that violate usury statutes, which has to do with a maximum interest rate that can be charged by law, those would also not be enforceable. Some agreements are opposed to public policy and might be unenforceable based on public policy grounds. Generally, agreements that restrain trade or limit competition are not going to be enforceable. However, we do make exception for non-compete clauses, so long as those clauses are reasonable in geographic scope and length of time. This is common for physicians. They may have to sign a contract with a non-compete clause that they won't go to another doctor's office or hospital within a certain radius and do the same type of practice because it may steal patients. So courts will enforce those as long as they are reasonable in geographic scope and in duration. Unconscionable agreements, those that are extremely one-sided and oppressive to one party, those may be thrown out as unenforceable. Yes, we have that freedom of contract that you can agree to whatever you agree to, but if it's so unfair that it's oppressive to the other party, it may be deemed unconscionable and a court may throw that out. Another area of agreements that are sometimes opposed to public policy is exculpatory clauses. An exculpatory clause is a clause in a contract that seeks to release a party from liability. And in some instances, if the exculpatory clause is extremely broad, then a court may strike that down and say that that is not enforceable. But if it's narrowly drawn and reasonable in scope, then a court may enforce it. An example of this, if you have a gym membership, that membership probably contains some sort of exculpatory clause that seeks to limit the gym's liability, and a court may enforce that as long as it is reasonable. I want to talk here a little bit about the statute of frauds. The statute of frauds is a concept that says certain contracts have to be in writing in order to be valid. And those contracts are prenuptial agreements, contracts that cannot be performed within 1 year, contracts involving real estate, contracts to pay someone else's debts, and then contracts involving the sale of goods for more than $500. Now, there are some exceptions that are recognized to this statute of frauds. For instance, if you have partially performed on a contract, that would indicate that there was an agreement, and the court may go ahead and enforce that agreement. If you admit in court that there was an agreement, then the court would go ahead and honor that agreement. And then promissory estoppel, which, if you remember from our last unit, that's a fairness tool that the court will pull out. And if there's just no other way to avoid unfairness, then the court may find that the contract is valid under the theory of promissory estoppel. Now, one question that can come up is, hey, what counts as a writing? So it has to be written. What counts as a writing? Well, it could be a formal typed up contract. That's probably what we usually think of, but it doesn't have to be. It could be a chain of emails back and forth. It could be something written on a napkin, so long as we can identify the parties and the terms of the agreement, and it usually has to be signed by the party against whom performance is sought. So if it meets those requirements, then it would be a sufficient writing. Another thing that can make a contract unenforceable is if there's lack of voluntary consent. And if there's lack of consent or mutual assent, then you really don't have an agreement in the first place. And so you may find this if there is fraud, mistake, undue influence, or duress at play. Another thing that can affect the enforceability of a contract is if there's a unilateral mistake of a material fact, meaning that one party was mistaken about a very important fact in the contract. Well, if that happens, the contract may still be enforceable. However, if the non-mistaken party knew or should have known of the mistake, or if there were inadvertent mathematical errors in the contract or in the agreement, then that may render the contract unenforceable. Another thing that can affect enforceability is the bilateral or mutual mistake of a material fact. If both parties are mistaken about a key fact in the contract, then the contract could be rescinded or undone by either party. Fraud can also affect the enforceability of a contract. If fraud is present, then the contract is voidable by the innocent party. You just have to look for that justifiable reliance on an intentional misrepresentation of a material fact. If that is present, then you have fraud, and that innocent party could choose to void the contract. Duress can also affect enforceability of the contract. If you enter into a contract under threat or use of force, then there was no genuine assent, no genuine agreement, and so the contract would be voidable. And then lastly, the contract may be unenforceable if there is undue influence, meaning that one party's influence was so strong that it overcame the other party's free will, and so there really wasn't an agreement there, and so the contract would be voidable. A situation where this undue influence might come up would be, the elderly person who is totally dependent on their caregiver, and their caregiver influences them to the point that the elderly person maybe signs over their house or something to their caregiver instead of passing it on to their children. That could be an example of undue influence.